Better. Thank you all for coming along to this session on Division 7A. It's been a long time coming. We've had a product up and running for a while in our whole platform. The only thing it's like the change in positions. I don't know if any of you have used the change in positions for trusts, but it's absolutely brilliant document. And essentially you can go on there, you can change the name this is in one document, change the name of the trust. You can retire or resign appointors, trustees, beneficiaries. Likewise, you can also appoint trustees, beneficiaries, appointors, and do a couple of other things. So it's an amazing document because I've seen on divorces, and this essentially came up on divorces where there's been a family law case where there's been court orders and the spouse has had to be removed from the trust documents as per the court orders as trustee, beneficiary, and in some cases appointor. And that's obviously really relevant. And I've had a look around and seen that a number of legal firms have been charging setting up a deed of removal of appointor, then a deed for removal of trustee, and then a deed for the removal of beneficiary. And each one of those they've charged $700 to $800 for. In my mind, again, to make something, for those of you who know Edward de Bono, the great lateral thinker, and he was saying in order to make something simple, you have to know it really well. And I spent 6 months building that system, and there's a couple other changes going to be made very shortly, but it's really good. I want to also now, as a consequence, you may not be aware, some of you, that there's been a case in 2020, Fairfax Retirement Fund, who moved from New South Wales to South Australia to start to use the South Australian jurisdiction for the Trustee Act in order to change the rule, in order to change the vesting date of their trust, which was set at 80 years under the New South Wales Trustee Act. But by moving to South Australia, there was no vesting date. So I need to start to implement that. That's one other thing that I can do in the change of positions is change of the vesting date. Again, all of these things are quite, you can either change the deed or upgrade the deed, which I wholly approve, and there you can switch jurisdiction to South Australia, and as a consequence of that, then it all happens. Or alternatively, if you keep an existing trust deed, and it doesn't matter where the trust deed comes from, you can then just change all of these positions. So anyway, the long story short, that was one of those ones that was sitting in the back of my mind. Shareholders and unit holders agreements is another one, but we're on top of that. Hybrid trusts another one, and that will be released next week, our hybrid trust. We're sort of stuck in this place at the moment, and look, I really deeply appreciate, first of all of your support. If you can see where we're going with this and the understanding, it's very exciting. But the platform that we've got now it's not up to the style that we expect at LightYear Docs or Abbott and Michael Jeffriess. The very name of LightYear, we want to be beyond our competitors, which we are in terms of our documentation, but we definitely aren't when it comes down to the side of not our documentation, but in terms of the actual platform itself. So if we have a look at that, it's a very interesting position. So with LightYear Docs 2, which they're currently building out on a very detailed basis, that will be released. We're hoping to go to a beta release around about September, October. So I know many of you are avid users, so I'd wholly encourage you to put your hands up and have a chat, or just send a support ticket that you'd like to be a beta user for it. Means that what we'll do now is we'll start to build templates and transfer them over. So I've got some of these hybrid ones, like the hybrid trust, and a few other things like the shareholders and unit holders, which are probably better off in the new platform, because the new platform will bring in a lot of integrations around Zero Practice Manager, class, BGL, and also obviously ASIC, which I think is pretty exciting. So that style is coming down the track. So just be wary of that. The other side is obviously Division 7A. So again, we operate on a process at both Abbott Mourly and also at LightYear Docs, a process called Kaizen. This was, believe it or not, was a professor, Robert Edwards Deeming, who first came up with this concept of continuous improvement. He was a business analyst or business theorist in the US, can you believe? And they derided his philosophy. And of course, the Japanese took it on and have taken it to heart, so that it's change actually is good. Now, many of us hate change. I know my mum doesn't, she's very, she just likes her stuff. You try to take her out of her stuff and like it just stresses her. And many of us are like that. But we see that continuous improvement is great. So when an issue pops up with one of our documents, and when I mean an issue is, the document doesn't do this, but we'd like to do this, then it's great because we have got our system, even the hot doc system, but the new one we've got, we can go in and change the templates really quickly. A couple of things about that is we are making continuous improvements. So some of you have probably jumped on the Protector and suddenly seen, oh my God, we've got endorsement of promissory notes and call options in there, which we didn't have before. So if you've done a Protector prior to maybe 2 or 3 months ago, it's worthwhile going in, reinvigorating it, relaunching it, and pulling out those endorsement of promissory notes and call options, because they are now a very important feature to that whole kit. What we do need to do is, obviously, because we're making so many improvements, we need to log them in on the site so you guys can do a search. So our tech team, headed by Ash and Laura, will be going through that process. Do you hear me, Laura? You'll be doing that so that you'll be able to see where continuous changes go. So to me, Kaizen works in absolutely perfectly with our system. So thank you very much. He was at Harvard University, and can you believe that? And yeah, we'll have Mitch, we will have the ability to do tax registrations and the whole box and dice. So again, if you've got any on your wish list around the integrations and the other sides that you like to have, just contact Alora, ELLORA, at lightyeardocs.com.au. So it's Alora at lightyeardocs.com.au. She'll put her email in there. And that's really important, because when we come round, you can see through the Moment Castle, we've built up to 30 documents just in that one interview. And so we want to build a lot more in there, including companies, ABNs, TFNs, and setup, so that one platform, if you've seen it, you'll be able to open that, and that will be a client platform where you'll be able to just pick and choose what documents you want. So it's a very exciting area we're going to. The next thing I just wanted to just show you is I've been working really heavily on, in fact, Mitch, we have got a hard copy solution coming up. Laura will put that in there, but it's coming up in the next couple of weeks. So you'll be doing hard copies on all of our documents, but particularly companies and trusts, etc. So that is there. We have got a sourcing for that, so that'll be available. One thing I wanted to show you is I've been working on the course. So traditionally, for those of you who've been in my courses before, they've been obviously either face-to-face or they've been online. What we're doing now is the course that's coming up on the 19th to 21st of July. We've got quite a few people on that, which is fantastic. That's a 3-day live course where I'll be going through it, and there'll be other speakers tuning in for that, where I'll be going through various issues. You'll be able to ask me questions. We'll be doing lots of case studies and application on areas. But we'll also give you, I'm hoping, the week of probably around about the 17th or 18th, or maybe even earlier than that, maybe towards the end of next week, that our platform will be ready for you to jump in for. So when you come to the course, you just don't get that 3 days. you get a lifetime access to the modules. I'm going to show you what it looks like. So lifetime access to all the modules. Now, importantly for that is that I've built the modules now, and it's going to take me all weekend and next week to do it. But that's just at that high level. So we're building them now, and then they'll only get better, because as thinking changes, more cases come out. If I come across a good article, we'll either be putting in the resource or into the course proper. I've actually got around about 100 resources sitting on my desktop, from cases, from tax rulings on resettlements, a great tax ruling. In fact, we're just working on a case at the moment, a private binding ruling where family trust or a discretionary trust, or family protection trust probably is the best, holds a residential property, and effectively then has a long-term lease over that property to the owners. And when that house is sold, there's no capital gains tax. So it's an interesting scenario, whether you use it all the time, but it's the best for great asset protection. So we'll be coming down and building that over the time. So for me, the course will now be my go-to baby for any issues, because what happens in my mind is I'm forever digging around the legislation, or you guys are asking me questions. I had David Alexander on yesterday and asked me about 10 questions, which is fantastic, but they covered everything from estate planning to asset protection to SMSFs. And so we're covering the whole box and dice. And I wanted to go and look at a couple of issues, but I had to dig around my computer to find the documents that I want, whereas this will all be in a repository. So I'm just going to bounce out of here just for a second. I'm not going to spend a huge amount of time. I just want to show you what it's going to look like. So this is what I'm building. It's called a RISE platform. In fact, you can have a look here. This is one of the modules on employee and family share plans, which is really important, that succession, that whole process. So what we've got there is this course has got 14 modules. I don't know why it's not loading. It's been painful, but anyway, let's get back to it. So you'll see here, okay, so there you go. There's the module 13, employee and family share plan. So we've got Michael who's built that, 5 benefits of an employee share plan. We've then got a video there. There will be another video live from the day that will come in. So when we're going through each of the modules, there'll be a separate link there for you to log into in order to complete that module on the day. So Laura is working that system out, but essentially it'll be through, I believe, Eventbrite. And then what we'll do is we'll record it, and then we'll put it up here as well. So there'll be another additional resource. And then of course we've got the tax benefits for employee share schemes, and there's quite a lot there. Other ones there you can go and have a look at. If I go here, so let me just go back to the start. Keep on bouncing around. Oh, here we go. I should go on this one, not the other one. Okay, so this is our succession and asset protection estate planning advisors accreditation. These are all our standards, and you can see here I've built out 4, a couple of more here at the end, and then we'll be going through. So I'll be looking at the importance of succession, the SPET market around the world. So if I have a look at that, again, I don't want to go through, I just want to show you what we'll have in there. So this is talking about the SPET market, why it's important to be right in the front. Talks about the relevant standards there, the competency standards that have been ratified by the Succession Asset Protection Estate Planning Advisors Association. These are then produced for you. There's a video there of me, which deals with those competency standards. So you can have a look through there. It's important to know those because obviously there'll be questions at the end on that. And it'll be easy. I mean, the questions I'm going to be telling on the way through. And how many competency standards are there? What's the name of the association? So you'll see there my thinking and how I'm a strategist, the things I'm looking at. We've got Edward de Bono, again, on creative thinking. And this is because we're dealing with families, we need to be thinking creatively. Some of the elements there. Wall Street Journal article, which I think is a really important one. The baby boomers and their parents have stockpiled a record $35 trillion, and they're starting to give it away. And they're giving it away for two reasons. One is that wills are pretty hotly contested in the US, as they are here. By giving it away prior to death, then obviously there's, it saves that issue. The second one over in the US, they have death duties. Again, by giving it away or putting it into a living trust, and that's the genesis of our family protection trust that we'll be going through in detail in the course, we're starting to find that's a huge change. So people are now starting to not wait until they die. They're actually doing all of their stuff beforehand. And that's, for those of you coming down the track, that's where that whole moat and castle comes in. We want to make sure that at the end of the day, there's nothing left in the estate, everything is protected. So it's a very exciting opportunity there, completely different way of thinking. And again, we've got deaths, and we go into the sole director companies, etc. But that sort of gives you an idea of what the course is about. Anyway, let's get back to Div7A. If you haven't booked in the course, again, if you can't make it at that time, it doesn't matter. The course you've seen, you'll actually be able to go in and do at your own time, complete it as you see fit. There'll be questions, etc. But again, there's nothing better than being during the time, because I'll have a lot of case studies, answer a lot of questions. So I can see that if I've given you this, you'll have homework for the night going through a couple of modules. But we'll be able to do a lot of case studies and a lot of questions on the day. Ideally, I'd love to do this face-to-face, and I'm hoping at some point in time that, when we come out of this COVID, and whether everyone's vaccinated or not vaccinated, but it goes down to when it goes out to everyone, that will be in a position, I'll be able to do 3-day courses up here. I live in the Sunshine Coast, just down from the Novotel, so it'd be great to have the courses up here, or alternatively in some of the major cities. So that will come, but at this present point in time, we're sort of in a situation that we've got to do the best we can. But I've built a really good course. As you can see, the 3-day course will be awesome, and you're going to get so much confidence. Anyway, let's get to the discussion proper. And have a look at Division 7A. Now, most of you, look, I know all of you guys are accountants anyway, so you've got to look. I'm if I have a look, I'm not really having a huge, you guys understand it. So the typical one is you got your family. Let's face it, we've all got that. I mean, I think when I left Now Infinity, I had huge Div7A issues which were cleared out by way of dividends. That's great, but there was a problem. So we've got the family protection trust there, or discretionary trust, that typically goes to the bucket company. The shareholders in the bucket company are obviously going to be the individuals. I saw someone had a bucket company with the shareholders being the trust, which was okay, so that's fine. So it may well be in that issue. If it's the shareholders, then obviously they'll take money out. I mean, they can take salary and wages. Superannuation is another element there. You can have a position of taking money out and using it for paying mortgage payments, paying obviously for watches and for cars and all that sort of stuff. And the same thing with trading companies. And I'm sure you've got clients with huge amounts of Div7A issues. So it's just one of those things that unfortunately at some point in time, it just keeps on creeping up. When you're in a startup company, it's a fantastic way to go down the track, although most startups don't have huge amounts of cash. So I just want to go through the ITAA guidelines for about 10 to 15 minutes. And then what I want to do is I'll show you our solution, our new solution, which is, again, it's a work in progress. So what I'd like you to do is, as we go through, I'm going to record this, and this will be available later on this afternoon or early tomorrow. I wouldn't mind you going through and having a look at what I've done in up on our platform, which is the Hot Docs platform. I'd like you to have a really good look at that. And importantly, if you believe there's any additions or changes we can make to the system, then please let me know before I release it next week. So we've got it into a good state. I didn't want to get it up because it's quite I've tried to put a lot in there from the Commissioner's rulings and guidelines. I've even gone further than that. You'll see a little bit later on. One of the issues there is a couple of you have asked, particularly good mate Steve has asked for ability to do dividend set-offs so that the company declares a dividend and then that's set off against the shareholders' loan, which I'm sure many of you have done. But really, the idea of doing book entries to declare a dividend and then set off a loan is problematical legally. And I've read enough papers on that. I'm sure many of you have done. So there's an easy way around it. So what I've built into the system, and you'll see a little bit later on, is the ability at any time to go and do a promissory note, which covers the dividend. So for example, if there's a $50,000 dividend that's going to be paid out to the client, then it's $50,000 cash, which will be by way of a promissory note. Obviously, the franking credits will be attached to that. The promissory note is just simply a cash component. So there's no way we can say that that dividend hasn't been paid. What will then happen from there is then the promissory note is then endorsed back, and endorsed is just it's like the round robin. So what we do is the promissor gives me the note, I hold the note there, and then I transfer that note back to the to anyone for that matter. I can transfer a promissory note to you, that's okay, or I can transfer that promissory note back to the company as a repayment of my Div7A loan, so that we've got some really good, strong documentation legalities. And that's the issue. A lot of us, we've done shortcuts in the past. For example, like trust distribution minutes and all that, we've done generalizations, but now our goal really is to start to do deep dives and make this as best as possible. Nothing is 100%, perfect, because we don't know. There's a lot of unknowns out there. We don't know what cases are going to come down the track. But what we do is we work with what we've got now and build solutions for that. That's really important. Anyway, if we just go through and have a look, so you'll see this a little bit later on. A private company may be taken to pay a dividend to an entity at the end of the company's income year if it loans an amount to an entity during the year when the entity is the shareholder or an associate of the shareholder of the company. Or a reasonable person would conclude that the payment was made because the entity was a shareholder or an associate of the shareholder. So that's an interesting one, that reasonableness test. The total of all dividends a private company is taken to pay under Division 7A is limited to its distributable surplus for that income year. So obviously, when we have a look at that, prima facie, all those dividends are going to be classified as unfranked dividends. So it's a huge penalty there for us. In terms of trusts, again, when we have a look, the commissioners brought that into the play, and that's sort of when we come back and the typical, if we have a look at, we've got the family trust, we'll transfer cash, or there may well be a UPE down to the company. Let's have a look at what the commissioner talks about that. So Division 7A applies to certain payments made by trustees to a shareholder or an associate of a shareholder of a private company where the company is presently entitled to an amount from the net income of the trust estate, and the whole of the amount has not been paid by a specified date, which is generally within 12 months. So that's the 12-month rule. However, the rules do not apply in all cases where there is an unpaid present entitlement. If a private company beneficiary, in respect of an unpaid present entitlement, provides financial accommodation to the trustee of a trust, so for example, it may well gift it, may well do whatever, or enters into a transaction with a trustee of a trust, it will be taken to make a loan to the trustee of the trust. So we've got to be really careful around that one, and we'll look at that a little bit later on. There are some exclusions, and these are the ones that obviously we're going to attack. It's not a dividend if it's made to another company, and that's pretty obvious. It just goes into the company's cash, and obviously its franking credit balance. The next three are the really important ones for us. So if the loan is satisfied, the minimum interest charge, so I'm going to show you that's actually built into the system, and the maximum return requirement, which is also built into the system and is made or put under a written agreement before the private company's lodgement day. So that's the key thing, is the private company's lodgement day. But again, it relates to the relevant income year. Again, so we've got plenty of latitude before we do that written agreement for the year ending 2021. One of the things that I would put to you is that if you've got some pretty sloppy documentation or you really haven't got a written agreement you believe is appropriate, what I might do, and again, I'll take up the same way we've done the investment strategy, I can do a deed of rectification ratification, which will be built into this Div7A program, so that you can then relate it back to earlier years just to tidy things up if you want to do that. So just let me know if that's an option that you'd like to pursue. It's made to purchase shares or rights under employee share scheme. That's very relevant, seeing we just had a look at that big issue around what Michael was saying. So employee share schemes, look, I've been going through them, and it's amazing some of the opportunities, particularly if you're doing these employee share trusts and being able to get tax deductions for contributions into these employee share trusts, and then the actual CGT date. You can have a discount date and then a CGT date for it is quite some time down the track. I mean, if they continue to work, then it's 15 years out, or when they leave the employment. But there's a lot of stuff around that, so that's very exciting. But again, we can have loans there to employees who are / shareholders under employee share plan. This is an important one. The amalgamated loan of the year is made. So I'm going to be talking, there's a separate section in about 2 or 3 minutes. We'll look at amalgamated loans. So let's have a look at these key features that the Commissioner talked about. So a loan that complies with the criteria set out in Section 109N of the Income Tax Assessment Act is explicitly exempted from being deemed to be a dividend. The criterions, should be the criterion, are summarised, or maybe it's not, the criterions are summarised below. Again, this is straight from the tax office. Where the tax office writes something, and that's why you saw in that employee share plan, I put everything down that the Commissioner's written. It's quite brilliant, because we can go in, ideally we go into the legislation itself. I can go to 109N if I had more time, but then I've got to have a look at how it's going to be interpreted by the policeman of 109N, which is the tax office. So that's why it's important. And you'll see when you do your Div7A kit that the Commissioner's guidelines and rulings are right up front in their face, so that the client is aware that you've given advice based on essentially the Commissioner's ruling. So anyway, the first one's a minimum interest rate, and most of you know that. The interest rate of the loan for each year after the year in which the loan was made must be greater than or equal to the benchmark interest rate for each year. So it's a floating rate. The current income year for 2021, 2022 is the same as last year, 2020 and 2021, which is 4.52%, which is a pretty low rate. But then again, when you're having a look at cash rates of 25 basis points, it's quite interesting. So they've published it annually now, so it's 4.52%, but that's built into the system anyway, so we'll have a look at that. Maximum term, again, there has been proposed changes that there will only be one term up to 10 years, but that's not in existence at the moment. The maximum term for a loan secured by a mortgage over real property is 25 years. The whole of the loan must be secured by a registered mortgage over the property. When the loan is first made, the market value of the property, less liabilities secured over the property of priorities loan, must be at least 110% of the amount of the loan. So that's not a bad one. So you've really got to, you can really ramp it up. And that's important, because you'll see in the kit, particularly with loans going down, the way we're doing the kit, it's not just for 1 year, it's future years and amalgamated loans within there. So again, you'll need to just keep on looking at that the 25 year, when you do the mortgage deed and get that you don't actually need to have it registered. There's no requirement in there, but it's probably not a bad idea anyway. In fact, yeah, it's probably not a bad idea anyway. But if you go down that track, what we need to do is just, if we look at the valuations, just compare them to obviously this maximum term. If you don't have the 25 years, then your maximum term is 7 years. And I think this is a pretty obvious. A loan which is made under a written agreement before the private company's lodgement date and meets the minimum interest rate and maximum term criteria will not be treated as a dividend in the income year the loan is made. So that's pretty crucial. So it's an income year by income year. So we've got a bit of flexibility to create these documents. Again, I want to use that Kaizen principle and get this to the best situation possible. For example, I can tell you, like when we originally drafted the investment strategies, I believed it was a really strong investment strategy, and I built it from the ground up. Then the commissioner came in with the ruling, or remember he sent the letters out to trustees and all auditors around about diversification, primarily as a consequence of LRBAs and property investments. So he then went through and made changes there. Then he issued in February 2019, I think it was, or 2019, I think. He issued quite detailed guidelines. In fact, it was 2020, detailed guidelines on what is required in investment strategy, including the retirement objectives for each and every member of the fund, their ages, their balances, etc. So this took a whole new ball game to investment strategies, which again, we had to create and build there. And it continues to build. Like right at that stage, we had cryptocurrency. We also built in, if those of you had reserves, prudential reserves management statement. Likewise, for those of you who did have crypto or derivatives, there's a special section in there whereby these are classified as alternative investments. And then if it's a derivative, which obviously crypto is not, but if it's a derivative such as options or futures or whatever, you've got a risk management statement, which you just press a button and it all pops out. And it's all part again of that kit. The more we can put in the kit, the better. So if we go down here further on that, a written agreement can be drafted to cover loans which will be made to a shareholder or their associate for a number of income years in the future. So that's good. So the agreement can carry on down the track. And how long can it carry on? Well, basically as long as the company's around. And many of you, I saw one yesterday, and many of you have that clients just keep on piling on those loans, the Div7A, and you're probably racking your hair, pulling your hair out, telling them they've got to address this issue, but a client doesn't understand doesn't understand. They just think, well, it seems to work all the time, so it works from there. There's no prescribed form for the written agreement. However, as a minimum, the agreement should identify the parties, pretty obvious, set out the essential terms of the loan. So you want to really make it, it's not just something you handwrite or you do. You want to have a really proper loan agreement that's been signed off by a lawyer. It's got the requirement to repay an interest rate payable and be signed and dated by the relevant parties. So there's a little example in the Commissioner's guidelines there. During the 2016 income year, Frame made an unsecured loan to Penelope, a shareholder of Frame Proprietary Limited. The loan will not be treated as a dividend in the 2016 income year if it's put under a written agreement before the private company's lodgement day. The term of the loan is no greater than 7 years, and the rate of interest rate payable in subsequent year equals or exceeds the benchmark interest rate for those years. So again, that written agreement is really the force. And most of you know my feeling is that if you don't have documentation, virtually you're out and about. It's you can't say, well, this is what we intended. It's important to have the documentation. That's why I'd rather go down the track. If we can automate and put in place that dividend payable by way of a promissory note and then subsequently being endorsed back, that's a lot stronger than if the Commissioner ever takes a journal entry, because in the past he has done, he's taken action against individuals who've instead of doing the recontribution strategy by way of a book entry, because there actually needs to be a payment out and a contribution in, which to me is the same thing. You've got to show there's a dividend being received by a person, and because that's one transaction, and then a loan set off, which is something quite separate from that. Amalgamated loans, which are really important. I think most of us know that, so I don't want to go through that in any great detail, but a private company will take and make an amalgamated loan during an income year if the company makes one or more loans to the shareholder or the associate during the year, and each loan, called a constituent loan, is not fully repaid before the company's lodgement date, will be treated as a dividend but for the exclusion for loans with a written agreement and has the same maximum term. So again, you might have some 7 and 25, but generally if you've got 25, you're going a registered mortgage, you're obviously going to choose registered mortgage. The amount of the amalgamated loan is the sum of the constituent loans have not been repaid before the lodgement date. So what I want to do now is I just wanted to go through and okay, sorry, Elijah, there's a I might go and turn that music off. It's there to try and let me just leave that. It's there to keep my little dogs calm. So if you just bear with me for 1 second, I'll just pause the recording. Okay, back again. Sorry about that. It's yeah, well, at least I know the microphone's working well. So apologies for that. Unfortunately, my little dogs get a bit crazy. So will these Div7A agreement, good question, Brad, be required each year? Or will they cover new loans made in future years? No, it depends. That's a really good question, and it's a great segue to bounce out of here and show you what I've built to date. Again, it's virtually ready to go. I can put it up on the system, but what I want to do for you is just to take you through what I've built, why I built it. So you can see here, this is in the Hot Docs platform, and it's virtually ready to go. And what we want to do is go through and have a look at what we've built. And if there's any changes, so Brad, I'm going to hold you up to your brilliantness, and obviously you can help me out there. Have a look at it. So I'm going to put the AM logo on there, so that's pretty easy. So first off is the documents. So let me just go through. Now, the first one I've got there is, and again, all of our systems, everything is optional. So I could go out and I could just do an umbrella loan agreement with nothing else. In fact, for many of you, that's all you need to do, because you might only have 7-year loans, you've got no dividend set-offs, and so it's not an issue. The good thing about the system, though, is going down the track, you may, once you've done one mortgage deed, then really there's no need to do a mortgage deed again. So you don't have to come in and press it. And likewise, if you're not doing this dividend set-off, then you don't need to do the promissory notes. So the umbrella agreement's important, but what I'm going to do is I'm going to do the whole shebang so you can see what it is. Every time I click that, up this pops. And as I said, this system, the user interface is pretty ugly, so you're going to love the new system anyway. So I've got a lender there. I've done this up previously, Bad Company. I was listening to that. For those of you who know Bad Company are, they're a pretty famous band, I think, from the 70s. So we've got Bad Company is the company, and we've just got John Smith, who is the director. So they're obviously going to be the lender in this instance. The borrower is, I've got two there. I've got Jane Smith and I've got John Smith as well. So they're borrowing jointly. Alternatively, I can just have it one person. To get rid of someone, you can see up here on the side, see this little arrow. You'll just have delete that repetition, and there John's gone. So I've just got Jane in that instance. With the new system, you'll actually be able to have a set of fields where it'll automatically either drag it in from XPM or wherever. But for each client, you'll have a set of fields that you'll then just be able to copy to any document that you want. Ideally, as I said, the moat and castle will end up being, hopefully, as long as the system works in the way I expect, will be an aggregation of around about our top 50 documents. So everything will be there anyway for you. And the reason I do that is that when you're down this PEPSTA issue and you're dealing with families always change. And I think that's crucial, because families are always changing. You need to go back in and amend or rectify or fix up documents on the fly. For example, if you've got an adult child who is, you know, getting a bit wayward, and they've got, or they're in a relationship you're not really happy about, and they've got a UPE to the family trust, then it seems to me it's not a bad idea to give that UPE back to the trust in that respect. So that's fairly important. So the next one we've got is the agreement details. So this is where everything starts to happen for us. So we choose where the loan agreement is going to be executed, and that's generally where the parties are. So we go from there. Date of the original agreement, I've got here 15th of July. So this is our first agreement. Date of commencement of the loan, 8th of July, or alternatively, it can be like the 1st of July if I want to do that. One of the elements there that we have a look, as I said before, is if you, once I release it, or if you believe there's a need there before, because your documentation really isn't up to scratch from years before, what we can do there is you add a overlay, which is what we did with the investment strategy. As I said before, the overlay there is that, look, we've done these in the past, not up to scratch. When we have a look at commissioners' rulings, things have changed, and what we're doing is we're rectifying past years. So you can go back and rectify, you know, last 4 or 5 years, and effectively rebuild if you want to do that. So that's another measure. But again, you know, I'll take your counsel on that one. Date of the mortgage deed. Again, this is assuming that you are going to use the 25-year term. We've got the principal loan amount, and you've got the commencement interest rate, and as I said, it's 4.52. So the loan date we've got here, which I've got, is probably, again, just humour me on this one, it should be the 7th of the 1st is the loan date. We might want to even stretch it out a little bit longer, because remember, we don't need to have this until the time that we actually lodge our private income, our private return. So we have a look at the amalgamated loan amount. So that's all the drawdowns that we have from the year, from the client paying their mortgage fees, buying watches, you know, paying car payments and all of that stuff. So instead of paying out as bonuses or salaries, we put it in a loan amount. So that's going to be the total in your book for the year. And you can see why these need to be done afterwards, because it's going to take a while for you to assess exactly what that loan amount is. Because if you don't get it right, one is it's too late to pay salaries, but it also means that effectively you're going to end up with an unfranked dividend problem. So the amalgamated loan amount there, we have it relating to an income year. And then we've got a choice. We can either go 7 years, and if we go 7 years, we don't need the mortgage agreement, or we can go 25 years. The minimum repayment, I haven't put a calculator on that, mainly because, look, I'm not sure. Maybe I think most of you could probably work out what your minimum repayment is. I'm just a bit reticent about doing calculators, particularly if we're going back down. But anyway, look, if need be, then you know, we can work out something around that one. So when we come around to next year, we might end up doing the same thing again. So this is what we're talking about, Brad. This is and I'll take you into the 2022. I'm going to take you in and show you. So this might have been 120,000. Income year 2021, or 2022, sorry. And again, we might have exhausted our facility for the mortgage, and then we work out a minimum repayment. And so that might be, I'll just put 400. It's actually got to be a number, actually. Sorry about that. So I can start building this, and as you can see, I'm just showing you the back end. We'll get in the documentation. You'll see a little bit further on from that one. Now, with that one, because I've clicked mortgage deed, you can see here, if I take mortgage deed off, the property doesn't go. I then need to just simply put in the details of the mortgage. So you need to go to the Land Titles Office or get access. You can get that from Eventum Optimum, from Michael Jeffriess. You just need to follow your number, land description, and put that all in there. We then, if you want to go down the track of doing the set off, again, this only pops up. So you can see here, if I don't have the dividend, well, it's popped up because obviously I clicked it before, so I get stuck in there, so I'd have to delete it. So what I've got there is the promissory note set off. So this is the 9th of July. The dividend promissory note is $10,000. The loan amount income year is 2021. So that's the year it's going to be set off. So you can do multiple promissory notes. So with that one, I'm probably, if you think it's going to be an issue around multiple notes, I might need to break it up and again put some tables in there. So again, this is just one of the areas that Kaizen I'm thinking about, is that we've just come up with this dividend set off. We're talking about 2021, which is okay, but what happens if we get down 3 years down the track and we're making minimum repayments and we're having one dividend payment? We may want to make minimum payments for prior years. So probably one of the first things I've just picked up after reading this and going through you is I'll probably have a table here for these promissory note set-offs. There'll only be one. Obviously, what will happen there is there'll only be one promissory note paid out, because that's the dividend paid out. It'll be then the endorsement back of that promissory note, which is the loan set-off. So we can either build a schedule in to say what it's for, or generally you can make the adjustments inside. I think a schedule is better because then it's explicable, it's specific, and specific is always better than general. So it's payable on demand because it means it comes here, and then when it goes back in, it's payable on demand. So that is the pure set-off. Absolutely perfect for that. How much does a promise to pay on the termination date? We've got 10,000. Is there compensation? You just go no. So there's no charges. And then we go down there and we'll have a look at what the documentation is for us. So I just got a couple of questions. If a loan is made in 2020 for say 100K, during 2021, 2 repayments are made, 10K on the 1st of January 2021 and 90K paid on the lodgement date of the tax return. Tax return was lodged on the same day. Then yeah, that'd be okay. So that'd satisfy the repayment in full with no interest charge. So what you've got is you can make as many payments as you want. So, which is an interesting point, because with a repayment in full, I'm presuming there, if there was a couple of dividend payments, rather than doing set-offs, we might just need to jump in and just use that promissory note. So for example, if I go back and I'll download these first, and then I'll go back and relaunch. So if I go back in here, with that one, you can actually use this just purely as a set-off. So in the documents, I can just go like that. And then with a promissory note, that will then push out all that relevant information. You'll still need to go to lender and borrower, but it doesn't have to be Div7A. So again, this has that use that you're looking at for that if there's a full repayment. Again, it's got to be obviously the money's coming out of the company and then going back in. So let's go and have a look at our little package that we've got. So this is our Div7A loan agreement and umbrella facility. Now, when it's umbrella, it means, in fact, what I'll do is I'll just go into what the wording is so you have a good understanding of that. And if you'd like to, again, have a look at this agreement, and I'd love you to have a look at it and think of any circumstances, or does it make sense? Is it easy to understand? Effectively, if you'd like to do that, just contact Laura again, and she'll go, she'll send it out to you. So again, as I said before, we've got the Commissioner's guidelines on Div7A. Anywhere in any of our documentation, if the Commissioner's got guidelines on it, and of course I'm going to put it in, because instead of putting stuff in from Abbott Mourly or LightYear docs, it's far better to have the Commissioner stuff, because one is it covers your butt, which is the whole issue, is because then you've got the stuff there for them to have a look at. So when we have a look at the Div7A loan agreement, we put the date in. Look, this is all the stuff that we've just had a look. The company, Jane Smith. The lender will lend money. So these are the background, lend monies to the borrower over time. And you should notice here, and for those of you who come to SEPET, we'll be looking at the difference between a deed and agreement. So this is an agreement rather than a deed. If this was a deed, that would say recitals. but it's just an agreement. The lender will lend monies to the borrower over time under this umbrella facility, subject to the terms and conditions of the loan, which will be found in this loan agreement. The purpose of the loan is to ensure that the advance of monies to the borrower is characterised as a loan is not a deemed unfranked dividend pursuant to Division 7A. Each loan agreement from the lender to the borrower is to be recorded and subject to terms and conditions that ensures that a loan amount as dated does not breach Division 7A. At any time, the borrower may seek the lender to offset monies, cheques or promissory notes owed to the borrower or in hand against one or more of the outstanding loan amounts. So what I've done is I've built in that facility to do that set off through the promissory notes. So under this loan agreement, I can't talk about dividends because that's quite a separate transaction, if that makes sense. So for example, you could, if there was salary and wages to be paid to an employee, and if you're shorted of cash, you could actually pay it by way of a promissory note, and then this has gone back as a set off. Does that make sense? So if you've got salary and you want to adjust their salary up, then you can effectively pay the promissory note out as compensation for salary and then put it back in under this agreement. So again, it's the promissory note going back in which changes the loan amount, not the dividend or the salary that's going out. Loan agreement, at the commencement date, the lender will loan monies to the borrower under the loan agreement. The loan agreement amount, the terms and conditions of the loan, and the date of loan will be recorded in Schedule 1. So that's an ongoing base. Each loan amount is to be treated as a separate loan from the lender to the borrower and treated by both parties as such. So the lender may lend further amounts by, anyway, we've got the term of the loan agreement, interest rates there. Repayment of loan amounts, capitalisation, obviously is not going to be an issue, refinancing, payout of loan amount, termination of loan agreements, obviously on insolvency, etc. Governing law, we've got there, New South Wales, we saw that. And then, again, this is a very robust loan agreement, talks about further drawdowns, mortgage deeds, etc. So if we go there, we've got the borrower being Jane Smith. Remember, if it was John Smith, I cancelled John Smith out, but John Smith would have come up. The lender is the company. And then we go to Schedule 1. So remember, we've put those amounts basically in there, all those, and then the dividend and promissory note set-offs with that one. So what I will do out of this, though, is because this Schedule 1 is going to be continually updated with this, and obviously we don't want to be punching out a loan agreement each and every time. So what I need to do is when I'll come in here, and again, sorry for thinking on the fly, what we'll do is we'll have in there an updated Schedule 1 post umbrella loan agreement. So if you go in there, you'll then be able to go into this amount here. Obviously we didn't tick the document, sorry about that. So you can see there, what we'll have is that'll pop up there for you. So you just have this schedule going on down the track. Anyway, back to the documents. So we've got that's the loan agreement. So that's an umbrella facility, and it's pretty typical, and it's modelled on many of the umbrella facilities that large corporations have. Okay, we've got the deed of promissory notes. Again, if we don't tick that, this is not going to come up. So the promissor is Bad Company, which is the company, and the promisee is Jane Smith. Now, when we have a look at it, Jane Smith, we obviously, I'm not sure why the address didn't come up. Maybe I didn't put the address in there, or it needs to be checked. The promissor will repay the promisee the said monies for the use of the monies in the terms of the agreement. So then again, we've got the $10,000 payable on termination date being on demand. So you've got virtually, this is akin to a check. It's just a little bit stronger than a check. It's covered by the Bills of Exchange Act in 1909. So it's been around a long time. In fact, promissory notes were used basically for trade. So domestic trade in those days, they wouldn't use checks. They would use promissory notes. So they were the precursor for that. For international trade, you use a bill of exchange. So much the same sort of thing, a little bit different. So we then go in there. So now our promissor company has given to Jane Smith the promissory note. And then what she does is she's now got the deed of endorsement. So she now holds that promissory note. And what you need to do is that promissory note with the deed once it has to be the executed promissory note, you now give those back and hold them in the company's permanent file. It's interesting. I'm not sure why that. Anyway, I'll go in why the address came up there and didn't before. But I'll let Alora do that if you're listening, Alora, because you're really good at doing that sort of stuff. And also test whether you're listening or not. So that goes back in, and then that means we can do a set-off. And then that set-off would obviously adjust the amalgamated loans that we have there. So that's pretty important. Good. She's listening. Well done. So you can make all the changes on the fly. And of course, then we've got our mortgage deed, which has been between Jane Smith and Bad Company. So we've got it over the property, and this is the one we're using for all of our stuff, whether it's the protector, etc. So we've got the mortgage deed as gets signed, and then essentially we're off and running. And you don't need to get the mortgage deed registered, but I'm just thinking is if there's the company, you may want to secure that loan just in case there's other creditors come in and if there's a trustee in bankruptcy for Jane Smith there, it'd be worthwhile making sure you register the mortgage. So again, use Venom Optimum for that. They're pretty good at doing all that sort of stuff. Anyway, I'm about 1 minute over from my perspective. So it's a really good kit. If you want to have a look at the umbrella agreement, the rest of the stuff you don't need to, because you've already seen that. But if you want to have a look at the umbrella agreement, contact Laura. I'd love to have your feedback because I know there's a few guys I know a few of you who are really in tune on all of this sort of stuff. So again, we need to be able to pull down agreements and rip them to shreds, so to speak. So it's the same thing. We're going to learn those skills as well at the SPEPA course. So that's our Div7A loan. I've even just had a look throughout just here, like the promissory notes, if they're going to be set off, we can set it off across a number of years if we want to make those minimum repayments. The formula for the minimum repayments, I'm not sure I'll do it in Hot Docs. We might do it in the next session, bearing in mind that LightYear Docs 2 will be out and about before you lodge your income tax returns for your clients anyway. So you might want to wait for that. But for those of you who want to get into it, you've got this Div7A. If you'd like to do those deed of rectification, ratification for past years, let me know, because it's a very easy process to add that extra document. As you can see there, we've got the ability to add quite a few documents. Anyway, it's Grant Abbott signing off, and hopefully we'll see you in a couple of weeks. I've got a very busy couple of weeks building the course, and then obviously the slides, but all that will go into that it's called the Learning Management System, which you're going to have lifetime access to, which will be very exciting. Anyway, it's Grant Abbott signing off, and sorry about the dogs and the noise.